Thank you everyone for being here. Pennsylvanians for Modern Courts and the Borough of Dormont, thank you. I want to give you a brief overview of who PMC is before we get into tonight's presentation. My name is Nina Schabach. I'm the Pittsburgh Program Coordinator for Pennsylvanians for Modern Courts, and I drove from Forest Hills, so I did not get as lost as I thought I would be. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. For over 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. While we are not offering legal advice today, we do hope this presentation is informative and educational to you all. On behalf of PMC, thank you so much for joining us tonight, and thank you to the Borough of Dormont for hosting us. After the event is over, you'll be receiving a recording of this program as well as a questionnaire over email. Filling out the questionnaire helps us bring you more workshops like this one. And for our presenter, Judge Hilary Wheatley, Judge Wheatley was elected to her judgeship in 2021. As a lawyer, she focused on civil litigation, focusing on real estate and estate planning. She is a native of Columbus and has served as a faculty member for the Pennsylvania Bar Institute. And I'll pull up our slideshow now. There we go.
All right. Hi, everybody. I'm Hilary Wheatley. Like Nina said, I am the magisterial district judge for the district that includes both Dormont and Mount Lebanon. I've been on the bench since January of 2022. And from 2007 until I took the bench in 2022, I worked for Papernick and Gefsky, like Nina also said, focusing on real estate law. In that capacity, I spent a ton of time in district court offices like my own, representing landlords and tenants in landlord-tenant cases, and then also taking those cases up on appeal to the Court of Common Pleas. So I'm going to speak to you tonight both as an experienced legal practitioner about these things, but also as a judge who hears the cases. I'm not giving you legal advice, but I'm talking to you about procedure. I'm not permitted to give you legal advice, and I won't be able to answer questions that seek advice about what to do, but we can talk about procedure. So we'll go ahead and move forward through the slides. And we're going to start with a brief introduction about the courts in Pennsylvania. So in Pennsylvania, we have, like, as the slide shows, a pyramid court system. Lowest level of the pyramid are the magisterial district courts. In Philadelphia, those are called municipal court, but they're the same idea. Magisterial districts are about equalized by population. The Commonwealth tries to honor municipal boundaries when they create municipal magisterial districts. Above the magisterial district courts are our county court of common pleas. Every county has its own court of common pleas, except for a couple of very sparsely populated counties up in the northern tier of the state that have kind of combined courts for two counties. Most courts of common pleas are divided into various divisions based on specialty of law. And then above the Court of Common Pleas are the state's intermediate appellate courts. There are two appellate courts in Pennsylvania. One is the Superior Court. The other is the Commonwealth Court. The best way to understand the distinction is the Commonwealth Court is where appeals go, where the government of any level is involved as a party. So if the Commonwealth is a defendant or a plaintiff in the case, or the Borough of Dormont is a plaintiff or defendant and the case is appealed, that would go to the Commonwealth Court. And then above it is our Pennsylvania Supreme Court. Every single judge who sits on that, all four of those levels of the court are elected by the voters. For magisterial district courts, the jurisdiction, like the slide says, includes small civil claims. So if you want to sue somebody like a contractor who doesn't do the work they should, and the value of that claim is $12,000 or less, you can file those with me. What we're here to talk extensively tonight about is landlord-tenant cases. So for those, what's important to know about that is landlord-tenant cases have to be filed in the district court where the real estate is located. For other cases, jurisdiction and venue are a little bit different, but for landlord-tenant cases, the real estate has to be located in the district, and that's where you file. We also hear summary cases, so if someone's charged with minor drug possession or public intoxication or violation of truancy law or code violations, we hear those. And then all district courts also have jurisdiction over the first two proceedings in a criminal case, including preliminary arraignments where bail is set and preliminary hearings, where the Commonwealth has to prove at least a minor bit of evidence to move the case forward. So we'll go ahead to the next slide. So like I said, common pleas is the next level up. It has both appellate jurisdiction from magisterial district courts. So if you bring a case before a district judge and you want to appeal it, you appeal to the Court of Common Pleas. But it is also a case of original jurisdiction for, say, civil claims over $12,000 and all sorts of other things. Relevant to tonight, all appeals from landlord-tenant cases will be filed in the Allegheny County Court of Common Pleas in the civil division and assigned to, within the civil division, the arbitration division. There's a whole bunch of other cases that end up in the civil division and in the Court of Common Pleas. Also relevant to landlord-tenant cases are appeals from district courts where, say, a landlord has needed to sue a former tenant for damage left to the property. That becomes a civil case and not a landlord-tenant case, even though the relationship was landlord-tenant. And those appeals will go downtown to the Court of Common Pleas. And before we move any further, I just want to introduce somebody who just walked in the room, Melissa Evans, who just
walked into the room.
She just walked in, and I'm introducing her because she is an attorney with Neighborhood Legal Services, and Neighborhood Legal Services represents a whole bunch of represents people on a whole bunch of things. I invited her to attend to share her thoughts as we go through these slides from a tenant representative or tenant attorney perspective and how kind of all of that works. So she's here, and I may ask her to pipe in from time to time, and obviously raise your hand if you want to share stuff too. She's also a Mount Lebanon resident, so she lives in the district. So this explains how the Court of Common Pleas is divided into divisions. So we have civil division, which is what we talked about. That's where appeals from landlord-tenant cases go, and cases involving personal injury and torts and contract disputes. Criminal division is only adults who have been charged with crimes. Family division includes divorce, child support, juvenile criminal cases, which is called juvenile delinquency court, and then PFAs are filed there, and juvenile dependency, when maybe a child needs to be removed from their home for whatever reason. That's all family division. And then orphans court is wills, estates, incapacitated parties, and appointments of guardians, and civil commitments, like when someone needs to be forcibly committed for mental health treatment. So that's our Court of Common Pleas. The boss of all of us in some ways is President Judge, or boss of me, I should say, not of you, is President Judge Susan Avashovic de La Sente. She's a former magisterial district judge. She is the boss of us in some ways, but really my boss are the Supreme Court justices and my district voters who get to decide whether I keep the job. All right, so this is somewhat relevant to landlord-tenant, but we always bring it up because it's real estate adjacent. There is a program in the Allegheny County Civil Division that will help people facing mortgage foreclosure. It is a special program that will help divert your case from full foreclosure through sheriff's sale to helping you reach an agreement with the mortgage lender to get caught back up on your mortgage. So we bring that up. There'll be information, and there's a link there that you can find in the slides on how to learn more and to determine if you're eligible. All right, so we went over the intermediate appellate courts. We'll just skip right over that one. And these are our Commonwealth Court judges. All of these judges are elected for 10 years, and some of them will be on the ballot this year because they'll be running for retention. You won't see their names on the ballot for retention until November. But yep, Commonwealth Court, that's where appeals not involving a government, or where appeals involving a government entity go. So like landlord-tenant cases, real estate related cases, unless it's like eminent domain involving the government, never end up before the Commonwealth Court.
It would typically include things like state agencies, so if you've ever filed for unemployment compensation and you appealed that, it would first go to the Unemployment Compensation Board of Review and then to the Commonwealth Court.
And it's also, I lost my train of thought. Oh, no, we'll move on. All right, Superior Court is appeals involving landlord-tenant cases, if they would ever make it to the Superior Court on appeal. Other real estate related appeals, contract disputes, personal injury, appeals of convictions by defendants who have been charged and convicted of a crime. And we've got a lot of Superior Court judges. Some of them also will be up for retention. They run for 10-year terms and then will be on the ballot for retention. And they've got some recent cases that are real estate adjacent that are listed there on the slide. You can search those case names on the interwebs and find more specifics about them. So one is about license plate registration. That's the suppression motion. That's criminal court, so we won't talk about that. And then another one is nursing home stuff, so we'll skip over that. Supreme Court, 7 Supreme Court justices, again, also elected for 10-year terms. Couple of them from Allegheny County. One of them will be on the retention ballot in November. And appeals to the Supreme Court are not automatic. You have to request that the Supreme Court hear your appeal, and they grant very few of them, similar to the United States Supreme Court. And they generally preside in Harrisburg, but sometimes are here, hearing arguments. And there are very few things that go automatically to the Supreme Court where they have original jurisdiction. Most of the work they do is discretionary review on appeals. And we'll skip over it. Let's skip that one. All right, here we go. Why you're all here. So we're here to talk about landlord-tenant cases. It is a complicated process both on the front end when you're trying to become a landlord or a tenant, trying to decide the rights and responsibilities when you're entering into the lease contract. And then it becomes even more complicated when the relationship sours in one way or another and you need to seek the assistance of the courts. As with most things, discrimination in housing is against the law. And so both Pennsylvania and federal law prohibit discrimination in the granting of housing. And you can be reported to and essentially prosecuted, for lack of a better term, by both the federal and state government for housing violations. And so if you believe you are the victim of discrimination, either in the your application or attempt to obtain housing, or in the use of your housing or the violation notices that you may be receiving from your landlord, you can report those violations to the agencies whose phone numbers are on these slides. And there are some pretty strict requirements with respect to landlords with what they're allowed to ask when allowing prospective tenants to complete applications, what they're permitted to consider and what they're permitted not to consider. And one really important one that is often used despite its prohibition is asking whether people have been arrested for or convicted of crimes. That is discrimination. You cannot and should not ask. If you're asked, you are permitted to leave it blank. And if you, like I said, if you feel like you've been a victim of discrimination, you don't generally file in court. You file complaints with these agencies, and then the agencies investigate and file themselves with you as the victim, for lack of a better word. Anything to add about discrimination claims, Melissa? Miss Evans.
You can call me, but anyone in here can call me Melissa. Not really, I mean, I think maybe you get into this a little further into the slide deck, but I would just point out one of the other sort of pitfalls that can come up, and there's some tension, is lots of landlords have a no pets policy, but people have service animals, and that would fall under an accommodation with regard to disability. So that's just something to be mindful of.
Right, yeah.
Those two things fit together.
Yeah, and that's, in my former life as a real estate attorney representing homeowners associations and planned communities that had no pet policies, that was something I dealt with a lot. And explaining that under the law, a service animal or a support animal is not a pet. And if the person who is the animal owner is entitled to that accommodation from that no pet policy, you cannot enforce pet rules on the animal. And it is a area of developing law that is ripe for misstep. So, you know, to the extent you are a landlord who is having to consider whether to grant an accommodation for a service or support animal, it is a place to tread very carefully and ask for advice before you open yourself up to a discrimination claim.
The other protected characteristic that's not listed here, and that's probably because it's only embodied presently in the Pittsburgh City Code, so presumably Dormont is outside the city,
Yes.
but if you have any housing issue in the city, know that domestic violence survivors or victims are also a protected characteristic, and it imposes some requirements on landlords, and there is currently a bill pending in Harrisburg to add that as a protected characteristic to the Pennsylvania landlord-tenant law. So that
Okay,
is
that's important.
in the works and potentially coming down the pike.
Okay, so we'll move on. I could, instead of looking like this the whole time, I could just look at the pieces of paper I printed in front of me.
I
All
can
right.
give you the keyboard.
Yeah, I could do that too. All right, so there's some examples of discrimination we'll go over, and it's hard to hear, it's probably hard to hear you speaking. Melissa, if you'll stand up and press that like face button on that, just turn it on now and until the light turns on, and that should help, and maybe pull it down a little closer. Thank you for that note from a member of our Zoom audience. All right, so examples of discrimination. A landlord meets with a member of a protected class who's a potential tenant and then quotes a higher rent than advertised. That might be a basis for a discrimination claim. Or denies it's available after it being advertised and confirming it's available, and then you go meet with them, and after the landlord meets with you, they deny that it's available. The one thing I get a lot, and I got more often in planned community law, but it comes up a lot, is rules regarding noise of children, or the ordinary play and behavior of children becoming a basis for notices of violation or notice of eviction from a landlord. Having children and children behaving like children do and making the normal noise of children is, you can't prohibit that. And to try and evict somebody on that basis would be considered discrimination on the basis of familial status. Now, obviously, there is a line beyond which it might not be considered discrimination, but it is another area to tread very carefully because of the laws governing discrimination. Again, on that familial status situation, you can't restrict properties to people without children, or you cannot restrict based on the number of people sharing a bedroom. You have a question?
Without children, does that specifically mean no children can live in?
Yes, yeah, that's not like, say, your children are 45 and you're in your 70s. It's like, it would be, you cannot allow children or people under the age of 18 to live here. We will not let people under 18 live here. On the other side of that, however, there is some permissibility in other areas of real estate that you can restrict be under 55 for like older senior citizens communities. That's the only kind of age discrimination it's not really age discrimination, but that's one place where drawing a line for age is permissible. Another basis for discrimination that we see a lot is that service animal, support animal, denying of the right to bring that animal, or demanding more information or proof regarding the animal and the need for the animal than is permitted under the law. There is a ton of information and guidance on the internet from experienced practitioners, from HUD, from all sorts of agencies and advocacy groups explaining exactly the process that landlords need to go through and tenants need to follow in order to be entitled to the reasonable accommodation to bring their animal. So to the extent you ever face those issues, there's a lot of great help available out there to figure out what to do next. Tenant rights in real estate, there are a lot that are inherent in the contract, whether the lease says it or not. Every landlord and every tenant, every landlord has an obligation to provide, and every tenant has an ability to assume that the property is habitable. What that means is heat in the winter, water running out of the faucets, a toilet that flushes, doors that lock, windows that close, appliances that work, a roof that doesn't leak. You know, the basics of housing. It's not about luxury versus, it's not like Motel 6 versus the Waldorf Astoria. It's like, can I close my doors and feel safe? And can I use the toilet when I need to? And can I shower? And can I cook my food? And is it warm enough in here that I am not freezing? There are a lot of things that people believe are violations of the warranty of habitability that don't rise to the level of it. But it's the basics for, a roof over your head. Mold might be another one, water leaks, things like that, sewage backups that aren't reasonably repaired. With respect to habitability, if you're a tenant and you believe you're living in conditions that may violate that, the best process is notify the landlord immediately that there is a condition that requires repair. The landlord is given the ability to reasonably repair it, and reasonableness is based on the problem. If it's like I have a tear in the screen of my window, they're going to probably be given more time under the law or in the courts to fix that versus it's 20 degrees below outside and my furnace is broken. So it's all based on the individual circumstances. At a certain point, if that item is or the items are not corrected, tenants have a whole lot of rights under the implied warranty of habitability in terms of how they enforce that right. And it's a complicated process to navigate, but just know that if you believe you are living in conditions that may violate that, there are rights that you have to enforce those. You also, as a tenant, have a right to use and enjoy your unit without interference by the landlord and by your neighbors. So what that means is you have a right to assume that your landlord isn't going to walk in your apartment without announcing it, or access your apartment without reasonable notice. And again, a violation of that may give you the right as a tenant to terminate your lease or seek other damages. And that is also a way that in some instances, again, beyond like reasonable noise when you're sharing walls with a neighbor, you may have a cause of action if something going on in an adjacent apartment or an adjacent home that your landlord has authority over. Like if it's a single family home next door, your landlord can't control that. But if it's the apartment next door, the apartment upstairs or downstairs, there are limited circumstances where you may have some rights with respect to being disturbed by your neighbors. Anything to add about that?
I was just going to go back to the implied warranty of habitability for a moment and just say one of the most important things as a tenant is to document whatever the issue is. So take photographs, keep a log of dates and times when you notified the landlord of the condition. Essentially build your evidence in the event you have to appear before Judge Wheatley on a landlord-tenant dispute.
Yeah, and once we get into the filing a case, we'll go over all of the things us judges like to see to make our jobs easier. And you also have a right to exclusive possession, and what that means is privacy, unlimited access to the entire thing that you rented. And the flip side of that is the landlord under the law and under your lease will have a right to inspect and gain access to the apartment or the home that you're renting, but they're required to give you reasonable notice of that. Unless it's an emergency, like they know water is gushing from a shower and they need to go in and turn it off. But otherwise, you have a right to expect that you're going to have privacy and notice before a landlord enters. So as a tenant, what's your job? Your job is to comply with the terms of the lease that you signed. And I would say before you comply with the terms of the lease you sign, your job is to make sure you've read the lease, all of it. And if you don't understand, ask questions until you understand. And then once you move in, your job is to pay your rent, pay your utilities if they're separate, not smoke if you've agreed to not smoke in the apartment. Don't bring a pet in if you've agreed not to bring a pet in. And as long as you do all of those things, you should be able to get to stay. And you have a right to assume that you are going to live in a place with water and heat and a roof. And if you don't, the landlord has some obligations and some rights on how they enforce the alleged violations of your lease. And that means you really do have to obey all of the terms. And that means if your lease says you've got to shovel your sidewalk, you've got to shovel your sidewalk in the winter, even if you didn't realize you had agreed to that. And you would know that you agreed to it if you had read your lease before you signed it. And it's important to make sure you get a copy and keep a copy so that if and when questions arise about maybe a souring relationship, you understand what your rights and duties and obligations are and what your options are if you want to terminate or move out. And again, back to what Melissa said earlier about documenting the complaints or the issues that you have with respect to the condition of the property. A landlord can't fix something in your property if they don't know about it. You can't come into a landlord-tenant hearing where your landlord's trying to evict you for non-payment of rent and say to a judge, I mean, you can, it's not going to be a successful statement most times, that I didn't pay my rent because the ceiling in my bedroom has been leaking for the last 12 months, and then have either me or the landlord ask you, did you notify the landlord? And you say no. They can't fix things they don't know about. And also, back to the reading the lease, there may be certain conditions in the property that the lease obligates you to repair. So make sure you understand what your obligations are in that regard. You want to keep track either via text or by a log, any communications you had with your landlord about repair requests, date and time, and what specifically you asked for, how long it took them to repair those things, so that in the event the relationship finds itself in court, you have documented your attempts to get these things repaired. And then on the back end of the landlord-tenant relationship, your obligation is to leave the property the way you found it. Now, that's accepting ordinary wear and tear. And what ordinary wear and tear means is different depending on how long you've lived in the property. You live in it for a year, ordinary wear and tear is different than if you've lived there for 10 years. And you're also required to leave it broom clean and free of debris. That is a term of art in the real estate world that means you've thoroughly cleaned the apartment and vacuumed and cleaned the sinks and the toilets and all of those things before you leave, and clean out the refrigerator. And if you don't do those things, that may give the landlord a cause of action for damage or repair or claims for having to move all your furniture out if you leave it behind.
Or the right to retain the security deposit.
Yes, the right to retain the security deposit, which we'll probably get to here at some point. So a landlord, because they own the real estate, have the right to decide the rules of the real estate to a certain extent, as long as they're not violating anti-discrimination laws. They are entitled to have a set of keys, but not to use them at whim. They have to notify you before they come in. But if you change the locks on your property, you have to give the landlords a key. If you have a keypad and that's how you get in and out, you need to notify your landlord that you have changed the key code on it. You have a right as a landlord to seek eviction through the courts and only through the courts if a tenant violates the lease in any respect, whether that's non-payment of rent or allowing additional people to live in the property that weren't on the lease or that weren't approved by the tenant, or bringing in an animal when you're not permitted to bring in an animal, smoking in the property when you're not permitted to smoke. But landlords, yeah, I see your question, Noah. Let me finish the thought I just had, and then I will answer. Noah's question was how much notice is required to access the apartment. So I just want to go back to this middle bullet point on this piece of paper, which is that the only way landlords are legally entitled to take the property back from you and lock you out and prohibit a tenant from access to their home is through a legal eviction where the constable either has shown up or the sheriff has shown up. Landlords may never lock you out on their own. And if they have violated the law and you have a cause of action. The notice for access by a landlord is generally dictated by the lease. The lease should say how much notice the landlord will give you before access. It does not always. And the landlord-tenant law is silent. Am I right on that? Do you know off the top of your head?
I
Melissa?
think that's correct. I think
Yeah.
it's controlled by the terms of the lease, except in those emergency situations like you described
Yeah.
before.
Yeah, so, and if it's not in a lease and it's not in the landlord-tenant law, notice is gonna be kind of based on the reasonable person standard. Was it reasonable for a landlord to text you at 11 PM saying I'm coming at 7 AM tomorrow? Maybe not, unless again, it's like near emergency or something. So yeah, the answer is it depends, which is a great lawyer answer to a question like how much notice is required. And landlords may require a security deposit. It's not required by law that you obtain one. One important note about landlord security deposits is that for the first year of a rental term, landlords may hold more than 1 month's rent as a security deposit. But if the landlord-tenant relationship continues beyond the first 12 months, they are prohibited from keeping as a deposit more than 1 month's rent. And so if when you move in, your landlord asks for first month's rent, last month's rent, and a security deposit, that last month's rent is actually security deposit. They are not permitted to hold in escrow beyond that first year any more than the first month's rent. And you have a right to request it either be applied to like month 13 or to ask for it to be returned to you. Landlords are not responsible for insuring, repairing, replacing, or protecting your personal belongings. And therefore, it is advisable when you are renting property to obtain renter's insurance, and some leases may require it. So a landlord has to, just like we talked about that implied warranty of habitability that is a tenant right, it is a landlord duty to comply with it and provide you a fit and habitable home. And we talked about a lot of these conditions previously. The one important note is if the damage or the break or the thing that needed fixed was caused by the tenant, the landlord's not required to pay for it. They may do the work and then bill you and add it to your tenant ledger, or they may require you to come out of pocket and hire the contractor or the plumber or whatever. But that's a conversation to have with the landlord if and when that happens. And if you're living in a multi-unit building, obviously the landlord has to maintain the common areas, provide habitable conditions in the common areas as well. And they have to also provide a safe home. And on the right-hand side of that slide are in red, some basics about a habitable home that we talked about earlier. All right. Under Pennsylvania law, landlords must notify tenants of their knowledge about the presence of lead paint or lead pipes in the home. There is in fact like a form notice and brochure that is required to be given by all landlords to all tenants before a lease is signed in Pennsylvania. And if part of the lease requires a tenant to pay some or all utilities separately, the landlord is required to provide separate meters for all of those things. So if you are paying utilities separate from your rent, meaning like your rent, it doesn't include everything, it's not like all in for one price, the landlord can only do that if they have separate meters.
So I'm in a 6-story building.
Okay.
And the prior owners of the building, the water was included in everything. And when this new company bought the building a couple years ago, what they said is like, we get the water bill for the whole building, including landscaping, everything. And we divide it by the number of occupied apartments, and then we get that bill. So it varies month to month. Can they not do that?
I don't believe they can, because it's not separately metered.
No, it's no. And
it's not included in your rent. It's over and above the rent that you pay?
Well, on the statement for the rent, it shows this is your rent fee, this is your water and sewer fee, this is your garage fee, this is your that fee. I mean,
and does that
itemized on the bill, but we'll
okay.
never see the water bill.
And does the water fee on your statement every month change?
Yeah.
Yeah, I don't think they can do that. Would you agree with that, Melissa?
I will be honest, I do not know.
Okay.
I'm not really a housing attorney.
Separate metering is so that you're only paying for the utilities you consume. So I believe that they are not permitted to do that, but that is a question I'm not going to guarantee I'm right about tonight. But I'm nearly certain that they are required to either include it in your rent or add separate water meters for each unit. And this is like a relatively new thing with the smoke alarm. You landlords under the law are required to replace a broken smoke alarm within 72 hours of notice of it being broken. Now that's not going to give a tenant the right to terminate the lease, but it is an important obligation of landlords and can result in some fines and consequences if not complied with. Okay, so a landlord's not permitted to sell your personal property to pay your rent. They're not permitted to lock you out. They're not permitted to shut off utilities. They're not permitted to harass you as a tenant in any way. And that's, harassment is different to everybody, but the standard in the court will be a reasonable person standard. And so harassment to you may not be harassment to me as a person. Ultimately, the judge is going to have to be the decider on whether or not the level of communication between a landlord and a tenant rises to the level of harassment. And again, like we talked about earlier, landlords may not enter the property or allow others to enter on their behalf without giving reasonable notice except in emergencies. Like we talked about for service animals and support animals, they are not pets, and landlords may not charge you a pet deposit or an animal deposit, or make you sign a pet lease because they're not pets. And they may not, current owners may not cancel your lease and make you move out if they've sold the building. They're required to give you notice that they've sold, but they are not permitted to cancel an existing lease. All of that is to say, down there at the bottom of the page, like we talked about earlier, landlords may not take possession of the property without a court order, despite some belief that you can. So the one thing I want you to know is, both for landlords and tenants, leases are important contracts. They are legally binding and enforceable in court, and it is important that you read it and you understand it. There is a form lease agreement that's been approved by the Attorney General will review and approve form leases to make sure that contracts are written in plain language for the average resident of Pennsylvania. But they're still really complicated documents. And it's important that you understand what you're agreeing to before you sign it. Because whether you understood it and whether you read it, if you sign it, you're bound by it. So that's an important pointer when you're looking at new apartments to move into. All right, so a lease is an agreement between a landlord and a tenant where one person owns the property and another person lives in it. Leases should be in writing, but the law doesn't always require them in writing unless they're for a really extended period of time. You're required or you're entitled to a copy of it. And you should keep it with you, keep it for your reference. And if you're not paying rent and you're living somewhere, you likely are not in a landlord-tenant relationship. Unless you have agreed to do work or perform, the landscaping services for the building in exchange for living in an apartment for free. That is likely considered a landlord-tenant relationship. But if you are letting someone live somewhere and or you are living somewhere and there is not an exchange of rent or other consideration would be like those services we talked about, you are not in a landlord-tenant relationship, and to regain possession of that property is not a landlord-tenant case. That is a ejectment case that has to go straight to the Court of Common Pleas. And that goes for things like you have a 25-year-old son that you let move in with you, and he's not paying rent and he's not doing anything around the house to help out, and you didn't have an agreement about that, and something has gone wrong and you want to force him to move out. That's not a landlord-tenant relationship. You have to file an ejectment. And you can't, if you've let him live there, you can't, under the law, lock him out. And the other important thing to know about leases is once you sign it, it can't be changed unless the parties agree and sign it and document that the terms have changed. Okay. What is Act 88 of 2024? I probably know what it is, but I don't know it by that, by its act name. Can you, Noah, can you explain what the idea behind Act 88 is of 2024, and we can talk about that?
I think it's a squatter's rights
Oh,
provision, and I
yeah.
will say I don't know anything
Okay.
about it.
If that's what it is, and we'll wait for Noah to pop in with an additional comment. So the landlord-tenant law changed, I am not familiar with that, and that's likely because if the law now allows people to remove squatters without using the courts to do so, that wouldn't come before me. And so I'll be honest, no, I apologize. I don't know the answer to that question. But if the landlord-tenant law has been amended to allow walkouts, which actually surprises me.
Again, it's just for squatters, so
Okay.
those who do not have a landlord-tenant agreement.
Okay.
Doesn't necessarily require that the agreement be in writing, but if you are, as you were describing, living somewhere that you are not paying some kind of money or other consideration like services rendered, you might fall within this category of squatter.
Yeah, and a squatter is different from someone who you let live there for free. Even if you let them live there for free and then you want them to leave, I don't, in my mind, without reading the act specifically in the definitions, that's not a squatter. A squatter is a stranger to you or the owner who found a way into this home and has decided to let themselves live there for free without the landlord's permission. All right, so we went over lease terms. Thank you. All right, so a lease, basics of a lease are who can live there, how many people how many people are living there, how much time you get to stay, and how much you have to pay. It will also include things like who's responsible for making the repairs, who's responsible for checking smoke alarms, when and if you're allowed to have visitors, when and how landlords must give notice before accessing the property, who's paying for utilities, what the late fee is, who's responsible for the other day-to-day maintenance of the property, how you can renew a lease, how you can terminate a lease, what the fee might be if you want to terminate early, and what steps you have to take to give notice of your intent to not renew or move out on both sides. It may also provide provisions about who's going to repair certain things in the home.
Let's talk about air conditioning. Now, here's the story.
Okay.
So I'm in this big building, not all the units have air conditioners. The prior owners of the building had a deal where if you buy an air conditioner, we'll install it for you, and then you just pay a little extra bump every month for the electricity for the summer. Very, very reasonable. When this other company bought the building about 3 years ago or so, the lease they presented with us said, and the old landlord said, well, if you ever move out, then, we'll uninstall the AC unit and you can take it with you. Well, by the time this new company bought the building, the AC was like 10 years old, and I knew it was gonna be dying soon. And the lease they presented to us said that if you have an air conditioner, we own it. And I thought, well, if they want to own this thing, it's going to die. That's going to mean that they're going to have to replace it. Am I right in that? The lease says they own the AC, because I called them when it died and they said, well, we don't have any in storage. If you want to buy one, we'll install it. And I said, well, no, the lease says you own it. And they said, well, we don't have any in storage. Ask us in the spring. So I'm going to have to deal with this again, since I mean, yeah, technically, historically, I bought the AC and now it's dead, but the lease I signed with them says specifically they own my air conditioner. Did I get you?
No, I'm just trying to walk the line of not giving you legal
Oh, okay,
advice
yeah.
without looking at the
Yeah.
document
Well,
itself.
Melissa, can you give me legal advice?
I'm not. I'm only permitted to provide legal advice to people who go through our intake process. But I mean, I guess I would say,
It feels suspect to me.
I think
As a real estate
Part.
on their part to decide what they own.
I think the question probably comes down to one, if I hearken back to my law school days 100 years ago, a question of whether the air conditioner becomes a fixture in the apartment, in which case they might have some ownership interest, as opposed to something that is movable property that you would own. And so it would really break on those lines. And without more information, which I don't need you to give me because I can't give you any advice, but that's sort of where the question lies. And also, just because they own it, it's not entirely clear whether that imposes on them on a duty to replace it.
Right. Those are different
So
things.
it's all a kind of, if this is a piece of equipment or device that is diminishing in value, right? Because over time it sort of deteriorates, then it may not be something that has any monetary value unless there was some kind of trade-in availability. So I think it's an interesting question, but I don't know that there's a clear-cut answer.
Yeah.
I think it could cut either way.
And the difference between a fixture, which is owned by the owner of the real estate, and personal property is basically how much damage would you cause to the property to remove this thing?
Oh, yeah.
If it's a
If you take it out, there's not gonna be a window there.
right, so that's where it falls. Like how do you decide whether something is a fixture that once you install it, it becomes property of the owner of the real estate versus something you can take away? It's like the difference between plugging in a toaster and hanging a kitchen cabinet on the wall. One is a fixture and one is personal property. And then, the owners of the real estate have obligations and duties with respect to the fixtures that they don't have with respect to personal property. All right, so fine print, there's always a lot, even if it's not fine print, it's actually in probably the normal size font in the paper, but, we talked about this earlier. During the first year of a lease, your security deposit cannot exceed 2 months' rent, no matter what a landlord may call it. If they have more than 2 months' rent in their escrow account, they are not permitted to. And that's after the first year of the lease. Once you're 2 years or more, they may not have in escrow more than 1 month's rent. And if you're in year 3, if the landlord has anything more than $100 of your money, it has to be in an interest-bearing bank account. When you move out as a tenant, if you want any or all of your security deposit back to the extent you're legally entitled to it, you must provide your landlord with a forwarding mailing address. And the landlord's obligations with respect to either returning your security deposit or providing you with an itemization of why they're not providing all or some of it does not start to run until you've provided a forwarding mailing address to your landlord. And that time period is 30 days. So landlords under the Landlord-Tenant Act are required to provide a written itemization to their tenant of what they deducted from the security deposit and any balance left. 30 days from the day the tenant provides a forwarding mailing address. So if you don't provide a forwarding mailing address till 9 months later, they have 9 months plus 30 days to return your security deposit. If you never provide it, they don't have to do those things. But if you provide it when you move out, the clock starts ticking when you provide the security deposit or provide the forwarding mailing address, or after you move out, whichever is later. If you provide your landlord notice that you're moving out and here's where I'm moving, and then don't move out for 45 days, they get the 30 days after you give them the property back to do the itemization and return the money. The itemization has to be detailed and explain exactly what the charges were, what they were for, and how much it costs. It can't just be like lump sum $600 cleaning fee. I mean, maybe it was $600, but they have to be able to produce or prove that they spent that actual money. And if you don't get the itemized list and or a refund of your full or partial security deposit within 30 days, tenants have a right under the landlord-tenant law to sue the landlord in district court for double return of the security deposit. So if you've deposited $1,200 with your landlord as your security deposit, you move out and you clean the property and you believe you've left it broom clean and free of debris and there's no major damage, absent ordinary wear and tear. And 45 days after you move out, you've gotten no itemization, no money back, and you've given the notice of reporting mailing address, you can file a lawsuit with your district judge in the area where the property was located, not where you now live, unless they're the same, seeking under the landlord-tenant law $2,400. And then the landlord would be obligated to come and defend that case and explain why they didn't, or maybe they tried, or you didn't, that becomes a lawsuit before a judge who then decides what to award and how much. Anything to add about that?
I would just go and underscore the itemization. Part of the reason for it to be a detailed itemized list is to be able to distinguish between things that are actually regular wear and tear and things that are damage to the property.
Yeah.
Because some landlords do want to kind of lump some things in, and it's just, the property ages and the carpeting, sometimes the pile gets beat down over time. That is not, if the landlord wants to replace that carpeting, that is not for it to come out of your lease. Now, if your carpet looks like a crime scene, that's a little bit different story.
And what's it look like a crime scene when you moved in? So,
that's another good point. Document how the property looks when you move in, and document how it looks when you move out. That can be very persuasive.
Yeah, it's really important on both sides of the lease to do that. Because landlords will also have claims that they will want to bring in court saying this tenant moved out and left my property in such a state of damage and disrepair that it cost me $10,000 to bring it back to the condition it was in, or $5,000 or $500 or whatever the number is. And in order to prove that, they need to show the court what it looked like the day you moved in, and then to show what it looked like when you moved out. And then also show the court how much they actually spent to repair it. Estimates are not good enough. The landlord needs to actually spend the money in order to have a cause of action to recover it. So documenting on both sides is really important. Date stamp pictures on your phone that you then print out and bring to the court, as opposed to handing the court your phone and asking them to look at the evidence on your phone. We'll talk about that in just a minute. And the other really important thing to look for in a lease, and we're almost to 7 o'clock and we haven't even gotten to filing of cases, but so we may skip a couple of slides, but the one really important thing to look for in a lease if you're a tenant is seeing whether the lease includes a waiver of your right as a tenant to notice to quit. What the Landlord-Tenant Act says is that landlords are required to give written notice in certain methods to tenants before they file an eviction case with a district judge to kick you out of your home. And the amount of time landlords are required to give under the Landlord-Tenant Act depends upon the basis for the eviction case. If it's end of term, it's one thing. If it's non-payment of rent, it's another. But at least many leases include a waiver of your right to that notice. And if you have waived your right to that notice, landlords do not have to give you a notice before they come to court and file a suit. You, however, under the rules of court, are entitled to notice of the hearing, which is different from your right to notice to quit. So just make sure you're paying attention to that and understand what right you're giving up.
That waiver clause can be somewhat limited or prohibited when you're talking about subsidized housing, which has a whole other set of rules.
Yes. Yeah, we are not talking about the very specific subsidized housing rules and procedures, because they are very unique and very different, and include a whole lot more hoops for both sides. All right, lead paint disclosure, we talked a little bit about it more. Just know that if you're a landlord or a tenant, you are bound by a law in Pennsylvania that mandates notice to tenants with a brochure and documenting of that. And a lease may not be enforceable if a landlord doesn't comply with that, and there are pretty hefty fines if you violate your obligations in that regard. All right, so we're getting to the point where we talk about cases between landlords and tenants, and like Melissa and I have talked to you about, it's important that you document all the communications you've had, whether you're a landlord or a tenant, because that's what's going to be determinative of, in part, who wins if you end up in court. So documenting everything and then printing out those communications to the extent they are via text or email and bringing them to court so that the judges can take a look at them. Again, giving your landlord written notice of a complaint is really important. Calling them, if you've got a landlord who's cooperative and responsive to phone calls, that's great, but documenting it either by sending an email if you have an email address, or text messages if you communicate with a property manager or your landlord directly, that's enough written notice. You don't have to put a stamp on an envelope and use the postal service for stuff like that. And in the city, you may be able to call 311 to file a complaint about repairs and conditions, but in municipalities and communities outside the city limits, 311 is not a complaint place to call. You may be able to call your local code enforcement officer or other government officials regarding conditions. All right, so there are some organizations that help provide pre-trial or pre-court mediation services for landlord-tenant relationships that have soured. Just Mediation is one that is free and confidential and voluntary and is a good resource. And then Good Shepherd is another one. And do you know of any others, Melissa, that help out?
I don't. A Neighborhood Legal, I think, is involved with Just Mediation and helps provide or recruit pro bono attorneys to serve in that capacity.
Yeah, it can be helpful because very often the disputes that end up in district courts, not very often, sometimes, right? They're just a breakdown in communication or a misunderstanding of people's rights and obligations as to who's required to do what. And if a neutral party can sit down and help you all sort that out, all the better, because no one's having to move and nobody's having to find a new tenant, and everybody can move on from the dispute.
And in my experience, I have not been before Judge Wheatley, but in my experience with other magisterial district justices, there's often a pause where the judge will ask the parties to maybe step outside for a moment and see if they can work it out. And a lot of times they can, even without an assigned neutral.
Yeah, in my court, for landlord-tenant cases, because of my prior experience and my prior life as a real estate attorney, I try to kind of do that during the hearing as opposed to leaving it to the parties, in particular in landlord-tenant situations, because it's complicated and it's fraught and it's emotional because it's somebody's home and it's somebody's investment and valuable investment. And to the extent I can help the parties work something out where they maybe just need more time to get the payment plan started or more time to repair something, I try to work with the parties, because I acknowledge the end goal of an eviction case is someone without a home, or the end result of an eviction case is someone without a home. But the longer someone who's not paying or not taking care of the real estate that somebody owns, the more financial damage the landlord experiences. And those are both valuable considerations. I mean, having a home is essential to everything that happens in our life, and having a safe and livable place to live and habitable place to live is essential. But the landlord's rights with respect to the ownership of their real estate are an equally important consideration. But we all do, to the extent we can, most magisterial district judges are interested in helping the parties work it out. Because the court system, when you put your dispute and the decision about this important matter in the hands of strangers, it's rarely going to turn out the way you want it to on either side. And so to the extent we can help the parties control the outcome, I think everybody walks away maybe a little less unhappy. Not everybody's always leaving happy, but a little less unhappy. So sometimes leases will provide that tenants have no right of early termination, or will provide provisions on how they terminate early. And if you want to move out early, regardless of why and regardless of whether you got a good excuse, you have to follow the terms of your lease. There is an overriding federal law that deals with active duty military personnel and being able to terminate early. But unless that situation applies to you, you have to comply with the terms of your lease regarding early termination.
And early termination may be impacted, it is impacted inside the city limits, may be impacted if that bill carries through the state senate with regard to domestic violence. If somebody needs to flee their domestic situation because of violence in the household, that is often a justifiable reason to break the lease. Again, under the city code, it is probably coming to the state law, and also in the subsidized housing space, there also can be requirements there with regard to early termination of the lease in those circumstances.
All right, so we're gonna try and, we were supposed to be done at 7, right? Or 7:30? Okay, we're gonna breeze through but cover the important stuff regarding actual eviction cases, because that's really like, you know, the gravy, so to speak, of what we're here about. So like we said earlier, you can't be kicked out and you can't take possession of property unless you start with the courts. You have to start in a magisterial district court and you have to ask for possession, and there are a couple of reasons you can ask for it. The lease has ended and the person hasn't moved out. The tenant has failed to pay rent. The tenant has engaged in illegal activity or has otherwise violated the conditions of a lease. And unless notice to quit has been waived, a landlord must comply with the Landlord-Tenant Act and or the terms of their lease regarding how notice to quit is given and how much time the notice to quit has to include. The most frequent thing that is that trips up landlords with respect to notices to quit is the following. If a lease includes a waiver of a notice to quit, and you as a landlord give a notice to quit, you are bound by what you said in it. So if the tenant has waived the notice to quit, and then you post a notice on the door that says you are in default of your lease because you have failed to pay December's rent, and you have 15 days to cure it, you are now bound by that, and you cannot file a lawsuit for eviction in court until day 16. And if you file before day 16, the proper thing to do for the judge who sees that case is to dismiss your case without prejudice because you did not have a cause of action on the date you filed. Even if by the time you get to court for your hearing, that notice period has expired. It is a jurisdictional issue for the court that if you file before the notice period or the cure period in the notice expires, you cannot pursue a claim until the notice period expires. So there are various ways notice can be given. Again, it'll depend on the Landlord-Tenant Act and the terms of your lease in how you give it, and how much time. And we'll skip over we'll skip over this slide so we can get to the kind of the nuts and bolts. And if notice is waived and notice is not given, even if there are particular judges who may ask you or insist on notice, you're not legally required to give notice if both parties have knowingly waived that right. And that may be cause for an appeal to the Court of Common Pleas. We've already talked about this box in red. You may not lock people out. Landlords may not engage in self-help. And if you, as a landlord, need to evict somebody for the 3 or 4 reasons you are permitted to, you have to file in the district court where the real estate is located. And the filing fee for that will be based on a couple of things. If there's money claimed, and the number of people on the lease will determine the filing fee. So my piece of advice about that is always call the court that you're going to be filing in to ask what the filing fee is if you're not going to the window to file and pay, so that you know what amount of a check to mail to the court with your filing fee. Okay, we'll move forward. So, landlord-tenant cases are between two parties, landlord's plaintiff, tenant is the defendant. The landlord has the burden of proof in the case where they're seeking possession. What that means is they have to prove that there was a lease, what the terms of the lease were, including how much the monthly rent is, how much the security deposit was, what the term of the lease was in terms of like when it was signed and or when the agreement was made and when it was going to expire. They have to prove that they gave notice if notice was required and or prove that notice was waived. The way you do that is by bringing a copy of the lease for the judge. The way you do not do that is by bringing the original lease and asking the judge or expecting the judge to make copies for everybody in the room, which happens more often than you would think. And that goes for any other documentary evidence that the parties need to bring to court. Do not bring one copy of it and expect that to work. District courts, like all courts in this Commonwealth, are courts with rules of evidence, and the rules of evidence require that you provide copies of every single document you want to introduce as evidence to the judge to everybody else that's involved in the case. So the best standard operating procedure, if you're going to court, is to bring at least 3 copies of everything with you. One for the judge, one for you, and one for the other side. You know, if you've got like a slew of pictures, at least one of those should be in color so that the judge can look at them. The judge may give you the color copies back and take the black and white ones. You know, color copies of photos are expensive, but if you want a judge to understand the context and the damage and the conditions on either side, color copies are going to be important. And evidence is not things on your phone. In landlord-tenant cases, the law does not require or give either side the right to have a lawyer appointed to represent them. There are certain circumstances where a tenant may be entitled to appointed representation in the Court of Common Pleas arbitration process. In limited circumstances, you may be entitled to representation by neighborhood legal services if you apply and the kind of case you have is within the narrow column of cases that they represent tenants on. Melissa, do you want to tell people?
Sure. You also have to qualify for our services financially. We represent people who are at 125% of the federal poverty line, which at present I think is $15,000 annual income for one individual with no dependents, and that number shifts. So that's the FPL. So I think 125% is like 17. But we do have some special programs, including we provide services to anyone who is over the age of 65 without regard to income. But we have intake staff who work closely with folks who call in, and if your case is a landlord-tenant case and you qualify for our services, then we can represent you if we have staff available to do so.
Yeah, so it's important to call as soon as you know you have a case and not the day of your hearing.
Oh, yeah.
Yeah, because they can't get there that quickly. They can't qualify you that quickly. Our lawyers' calendars are really booked way in advance. So who else is involved in a landlord-tenant case? Obviously, the judge who will preside over your case. And court staff in the offices of the district courts, just like judges, are not permitted to give legal advice. They can tell you and answer questions about procedure and filing fees and where to go to do this and where to go to do that, but they can't give you advice on how or how to decide what to do next. Lawyers are not permitted to give legal advice. Court staff are not trained lawyers. Some of them may be, but we are not permitted to give legal advice. Lawyers may be there representing one side or the other, but you're not entitled to appointed representation for landlord-tenant cases. If you are not represented, the term of art in the law is pro se. That means you are representing yourself. But even if you're pro se, you are obligated to understand the rules and procedures and the laws and the process. And pro se parties do not get a break when it comes to their obligation to comply with the rules of evidence, the rules of procedure, and their burdens of proof. Judges cannot and should not hold the hands of pro se parties in helping them through their cases and helping them make the arguments they need. Some courts have courtroom security all of the time or some of the time. Some courts have metal detectors or wands that are used by constables for security. And then if you're downtown, there's significantly more security provided either by sheriffs or private security companies. Landlord-tenant cases, like most cases in district courts, are public, which means it is open to the public, and absent exigent or extraordinary circumstances, the public would be permitted to sit in on your landlord-tenant hearing if they ask. Unless there's a juvenile involved, which wouldn't be the case in landlord-tenant cases. So you file your landlord-tenant case in the district where the real estate is located. If your amount of rent as a landlord that you're claiming and wanting to be awarded is over $12,000, it is a complicated analysis to determine whether or not you can still file in district court, because district courts, no matter whether you're legally entitled to more than 12, cannot award you more than $12,000. We don't have jurisdiction or authority to do that. And so it is best not to wait so long that you need to ask for more than $12,000 in a landlord-tenant case, because there's a possibility that you are waiving anything over than $12,000 and or a possibility that no court has original jurisdiction because of these waiver issues. So to file a landlord-tenant complaint, landlord has to fill out a actual complaint form. They're available on the UJS website, the PA Court's website. They're also available in hard copy form at your district court office. It is important that that is fully filled out and all the necessary boxes are checked. Landlords need to provide the name of the landlord, the name and address of the tenants. Phone numbers for both parties are really helpful so that in cases like last week where our courts were closed for bad weather in an emergency, or if we have to close because the lights go out or we have no water, we can reach you. If we can't reach you and we have to continue your case, you're going to show up and be annoyed and frustrated that we didn't notify you, but we can't notify you if we don't have your phone number. The courts, most courts will not have someone to help you fill out the form. So you got to figure out how to fill it out yourself. And it has to be signed. You should check local court rules and call court staff if you have questions about procedures. The one pet peeve or the one mistake I see most often on landlord-tenant complaints is that the box that informs the court of the basis for the eviction filing is left blank or filled out incorrectly. That is paragraph 5 on the landlord-tenant complaint for those of you who are familiar with it. It says something like, I am seeking possession of this real estate because the lease has expired, the terms of the lease have been violated, or rent is unpaid. If rent is unpaid, you check the third box. You do not check the second box and say the lease has been violated because the tenant has failed to pay rent. Paragraph 5 of the landlord-tenant complaint is consistently left blank. And if it is not filled out, a judge does not know what kind of judgment you as a landlord may be entitled to, because whether you're suing for unpaid rent or for some other reason will determine what sort of judgment the judge is required to enter for you if you win. So once a complaint is filed, a hearing is scheduled. The rules of court require that the first hearing, absent complicated court scheduling and holidays, the first hearing be scheduled within 7 to 10 days of the filing of the complaint. And you as the landlord or as the tenant are entitled to notice of the complaint filing and your hearing date. That notice is required to either be hand delivered to you or posted on your property if the constable or the process server cannot find you personally at your home, and it is also mailed. What will be posted on your door is a hearing notice and copy of the landlord-tenant complaint. and it will have the date, time, and location of the hearing where you need to appear. It's important when you see those notices to look at the address in the hearing date time box to confirm that you're going to the court where the hearing was filed. There are instances where a landlord-tenant complaint, I'll give an example from my court, may be filed in my office. But if it is filed, for example, by the law firm that I used to work for, or by a management company that I used to represent, we have a blanket reassignment or recusal order that automatically sends those cases to a different court. And so while the complaint will have my name in the top, or whatever home judge of the real estate in the top left corner, your hearing may be taking place somewhere else. But it will still be Judge Wheatley's case if it's within Lebanon or Dormont, but you may be going to see Judge Stevens or Judge Motznick because of conflicts of interest the judge may have with one of the parties. So always pay attention to the address that's in that hearing notice. And a tenant is required to appear for the hearing. And if they don't, landlords win by default. You've got to show up if you want anything other than the landlord winning for nearly everything they ask for. If you don't show up, the landlord is presumed to be entitled to what they're asking for. They don't have to present evidence in some, I mean, they have to prove that there's a lease and what the rent is and all of those things, but they, you know, if you're, let's say you're not paying rent, yes, Yes, I see a comment now, and we'll talk about it in just a second. If you're not paying rent because of the condition of the property and you've withheld it, you're not going to get to present that evidence and maybe win and not avoid eviction if you don't show up to present your evidence on that issue. So Noah just put in a comment about the rules of court for landlord-tenant cases changing with respect to service of process or service of notice of the hearing, and I went over that briefly, but what it does require is a good faith attempt to actually personally serve someone. So the process used to essentially be that a constable would, what we call lick and stick, for lack of a better word. They would, you know, lick a notice and stick it on the door, and that would be considered good service of a landlord-tenant complaint. The rules now require a good faith effort to personally hand the tenant notice. The way that's currently being interpreted, and a lot of MDJs are having conversations internally about what instructions to give our constables about that now. What seems to be kind of what we've settled on, absent more guidance, is you've got to knock on the front door, wait a little bit. If you can find a back door, knock on a back door, wait a little bit. But you don't have to put, like, to constables, you don't have to put your personal physical safety at risk. If there is a big dog in the backyard, you don't have to go in the backyard. But you gotta knock on the door. You gotta try and find the person personally. If it's a secure building where you can't get beyond a main entry door, you are not expected to try, constables are not expected to try and find a way to get into a secure building, but they've got to make at least a good faith effort to personally serve the tenant with notice of the complaint in the hearing and document that for the purposes of the file, so that if there is a landlord hearing that takes place and a tenant does not appear, the landlord is only entitled to that default judgment or the win, so to speak, if a tenant doesn't appear, if we have documentation in the file that there has been good service on the tenant. And so then you come to the hearing, and there's a hearing, and the parties will be sworn in by the judge. It is not a court of record, but we still ask you to put your right hand up and swear that you're going to tell the truth, and we have to trust that you're going to. We don't have lie detector tests in our court offices. Not that any of us would know how to administer those. And because it's a landlord's case, the landlord has to meet their burden, and their burden is to prove that they're entitled to the judgment they're asking for. So we talked a little bit about the documents they need and what they have to prove and what they need to bring. And then once the landlord tells the judge everything they think the landlord or the judge needs to know, the tenant is given an opportunity to respond, whether to explain why they haven't paid their rent, or why it's so loud, or that the landlord is lying, if they believe the landlord is lying, or if there's just a differing opinion on the facts. And ultimately, the judge is going to have to make a decision within 3 days of the hearing. And notice of the judgment in a landlord-tenant case that will come out to both the landlord and the tenant will notify the tenant and the landlord of their appeal rights. How much time you have to file an appeal depends upon which portion of the judgment you want to appeal. If it is an appeal of the possession portion of the judgment or the eviction portion of the judgment, you have to file an appeal within 10 days of the judge's order. If it's just about money, you have 30 days to file. If you only want to appeal the monetary portion of the judgment, you have 30 days to file. And that's a really strict deadline. So it's important that you look at the date of the notice on your judgment and count 10 days from that date and make sure you are in court before close of business on that 10th day. If your 10th day falls on a Saturday, Sunday, or court holiday, the 10th day is the next court business day. So if your day 10 is a Saturday, you have until the close of business on Monday or the next day the court is open to file your appeal. So this is the new notice about people, how you give notice to people who may not be tenants, and it allows for intervention by third parties and the ability to appear at a hearing on a landlord-tenant complaint and or make an intervention request. This procedure is new enough in the courts and new enough to me that I've not seen it happen in reality yet. So there's not a lot of practiced or real world stories to talk about how and when this applies. But just know that there are certain circumstances where someone whose name is not on the list may have intervention rights or a right to participate in a landlord-tenant proceeding. So what should a landlord bring? And this is the same goes for a tenant. You should bring a copy of the lease, not the original to hand to the judge, but copies for everybody. Any relevant inspection licenses or occupancy agreements, if that's relevant to the case. Most magisterial district judges are not asking that you have an occupancy permit for your apartment unless it's relevant to a habitability issue. You need a copy of the notice to quit if you gave one, not a picture of it on your phone. And you need to be able to prove on what date it was given and how it was given. You need to bring copies of any unpaid bills or other receipts for damages you are claiming, photographs of damages, proof of payment, a current tenant ledger that shows the amount of money you're asking for. It's good practice to bring one that goes back to the last zero ledger balance so that the court can see the full picture of how we got to where we are today. Printed out copies of communications between the parties, not the text messages that you want to show me on your phone. And I keep bringing this up because the number of people who try to show district judges their phones and think that that's admissible evidence astounds me weekly. All right, and the same goes for a tenant. You bring everything you think the judge needs to see to prove what you want the judge to know. Printed out copies, not on your phone. And do not say, I can bring it next time. Because there is no next time. Your hearing is today, and I can't let you come back and bring me evidence at another time unless all of the parties have agreed to continue the hearing. If you are a tenant suing for refund of your security deposit, you got to bring your lease. You need to provide proof of how and when you gave a forwarding mailing address and how much your security deposit was. If you've made a request to the landlord for return of your security deposit, bring copies of those requests as well. All right, so what happens? You bring all your documents. We swear you in. The landlord will tell me what the landlord thinks I need to know. The tenant will tell me what the tenant thinks I need to know. Some judges do landlord-tenant cases very differently than others. So my biggest piece of practical advice to everybody listening to this session is don't assume that because you can do it in Judge A's courtroom this way, that Judge B or C or D are going to let you do it that way. And don't assume that the judge who used to have the office 5 years ago and let you do it one way is going to be the way the new judge lets you do things. The best way to ensure that you are always going to get the result you want and think you're entitled to is to follow the rules of evidence and the rules of procedure and be prepared to present a case like you are presenting to a judge in the court of common pleas, because those rules of evidence apply. And if you have all of that and you've proven your case, you're likely to win. But if you don't have all of those things and you don't comply with the rules of evidence and the rules of procedure and say, but Judge so-and-so used to let me come here with nothing, that's not, you don't win that way. And that's not a compelling argument to the newly elected judge who's sitting in their courtroom. So after the case is heard, the judge will either rule from the bench and tell you what order they're entering, or they will say to you, we're going to send you the judgment in the mail. A lot of times that depends on how many people are sitting in the waiting room for the court's docket that day and whether they have time to talk about what's going to happen next. In my courtroom, my standard operating procedure only for landlord-tenant cases is to explain what I'm doing while you're in the courtroom, because I want tenants and landlords to leave understanding what their rights are when they walk out the door. I want a landlord and a tenant to understand what a pay and stay judgment is versus a eviction judgment. I want tenants to understand what 10 days for appeal means and what the consequences of missing that appeal are. And what will happen if a possession judgment is entered, no appeal is filed, and how a landlord will then legally remove somebody from the property. So I generally try to explain, at least procedurally, what judgment I'm going to enter and what's going to happen next. Sometimes I need to do some math calculations in my courtroom to determine what rent is owed and what deductions need to be made for breach of warranty of habitability or take off late fees that are too high. But you're at least likely to leave my courtroom and many courtrooms knowing the big picture of what your judgment's going to be. And so if a judgment for possession is entered, whether it's a pay and stay judgment, which I will explain what that means, or it's just a straight possession judgment, and the appeal period has expired, which I have said is 10 days, on day 11 or any day thereafter, the landlord would, if they want the property and they're legally entitled to it, they have to come back to the district court office and ask that the office issue an order of possession. That is what eventually, but not on the day the order is issued, gives the landlord the ability to actually lock you out, but it's not the landlord who's doing the locking out. So if an order of possession is requested from a district court, the next step is that a court's constable will go to the property and post an eviction date notice on the door. That is generally 10 days from the date the notice is posted, and it will say specifically, I, Constable John, will be back on this date at this time to evict you from the property. And on that date and time, the constable will show up, the landlord's required to show up, and if the tenant is still in the property, the constable has to physically remove them or ask them to leave, and then the landlord, then and only then may the landlord change the locks on the property. And that's a tough thing for constables to have to do, because sometimes they do have to physically remove people from the property, and then they're left standing on their front porch with all their belongings in the house, and then this whole getting your stuff back situation arises, which is a whole nother workshop that we could talk about. But only then, when the constable shows up on the eviction date, is the time when a landlord may physically lock you out. So a pay and stay judgment is the kind of judgment that landlords are entitled to if and only if the basis for the eviction is non-payment of rent. If it's end of term or end of term and non-payment, or end of term in violation of the lease terms, like you let somebody else move in or you brought a dog, you don't get pay and stay in that situation. But if it's just non-payment of rent, if the only thing that you have done wrong is not pay your rent, then the only kind of judgment a landlord may enter is a pay and stay. And it doesn't say that on the judgment, that's just what we all call it. It says possession is granted if money judgment is not satisfied, but it's a pay and stay judgment. What that means is you have until that day that the constable shows up to physically remove you from the property to pay your delinquency in the monetary judgment from the judge. And if you do, you get to stay. So that's why it's called pay and stay. And what that means is on the eviction date at 10:30 on February 14th, if that's the date the constable's coming, you can hand the constable the $2,502 that you owe according to the judgment, and you get to stay. So but you only get that if the only basis is non-payment of rent. You can get a stay of eviction a variety of ways: by filing an appeal, by filing a motion for late appeal if you've missed the 10-day deadline, and then by following all the rules and procedures in the Court of Common Pleas for getting to stay in possession of the property while your appeal is pending. The most important aspect of that is that very often tenants will have an obligation while their appeal is pending in the Court of Common Pleas to pay their monthly rent into the court's escrow account on certain dates. And if you're a tenant and you have filed an appeal, you will leave your appeal filing, standing at the counter and filing paperwork, you will leave with a form that says you have to pay X dollars on this date and X dollars on this date, for the next couple of months. And if you don't pay that money, even if your appeal is still pending, the landlord there are procedures in place that will allow the landlord to evict you with the constable if you're not paying your monthly rent into court. So it's important that when you leave Allegheny County Department of Court Records, Housing Court, when you file your appeal, that you understand and look at all of that paperwork you're handed. Because there are circumstances where you have filed an appeal as a tenant of the eviction portion, and because you don't pay your rent, you get evicted, but your case is still proceeding on appeal, which is kind of moot at that point because you've been kicked out. So it's important to understand all of those documents that the court hands you. And there may be some waiver, you may have eligibility for a waiver of filing fees and appeal filing fees if you meet the informa pauperis standards, which is essentially, poverty level standards, and depends upon the number of people in the home and the community and the county. And there would be a form that you would fill out when you file your appeal requesting approval for informa pauperis status, and you're required to provide some details about your income and benefits you receive, number of people in the household, et cetera. And then that would then be reviewed and ordered, approved or denied by a common pleas judge. And you can also request informa pauperis status in the Court of Common or in district courts for certain cases. It's rare that a landlord is going to qualify for informa pauperis status, and tenants don't have a filing fee for district court cases, for landlord-tenant cases. But if you're filing a civil case for something like refund of your security deposit and you cannot afford the filing fee, you can request an informa pauperis form.
And if you're represented by Neighborhood Legal, there's a standing rule of civil procedure and a local rule that says we can just say we represent you, that you are indigent, and that we are not charging you anything, and that will automatically be granted. It doesn't even require a motion.
Okay, great. All right, so like we said, if either side is dissatisfied with the ruling of the court for whatever reason, you have a right to file an appeal with the Court of Common Pleas. You do that in the City County building, which is the building with the Mayor Caligiuri statue out front on Grant Street, in the Department of Court Records. There is specific for landlord-tenant cases something called the Housing Court Help Desk. And that's where landlords and tenants go to file their appeals, because they have specially trained landlord-tenant procedure clerks at that desk to help both sides, whoever's filing the appeal, fill the paperwork out and understand what happens next. They too can't give legal advice, but they can tell you what the procedure is going to be. And you have to, like we said, 10 days for possession, 30 days for money. If you're filing an appeal of a possession judgment within 10 days, the monetary portion of that award goes with it automatically. You don't have to then file a separate appeal for the money. And one thing I'll talk about before we get to the websites, if you file an appeal with the Court of Common Pleas on a landlord-tenant case, your case will be scheduled for an arbitration hearing before a panel of lawyers who are experienced in and knowledgeable about landlord-tenant law. That panel of arbitrators is 3 attorneys, and your landlord-tenant appeal, how quickly are they happening these days? Do you know?
I do not.
Okay. It used to be pre-COVID, because I have not practiced in the courts post-COVID, once eviction cases started yet. It used to be within a month. But they're generally on Tuesdays and Thursdays, and you will have a hearing before an arbitration panel, and it is a brand new case. So it's not a review to decide whether the judge made a mistake and then overturning the judge's mistake. It is a brand new case, like the prior judge's decision never even happened, which means that you can't say, I gave all this evidence to the judge before, and so I don't have it with me today. And you can't say, well, Judge Wheatley ruled this way, and so I want you to rule this way. You've got to prove your case on both sides from scratch, like the hearing in the district court never happened, because it's a de novo appeal. And then there are also appeal rights from an arbitration panel award too, that would then get you before a judge or a jury for a trial. Again, de novo. So you got to bring copies of all your documents with you for a third time. All right, so here's all sorts of websites for you about access to additional information about landlord-tenant law, landlord-tenant rights, how security deposit works, tenants' rights. Is the PMC brochure about landlord-tenant rights and landlord-tenants available online? You know, that like color. Yeah. Well, there's like, no, it's not even a brochure. It's like 8.5 by 11 pamphlet. Do you know which one I'm talking about?
I do.
Okay, I have those in my district court, and I love to make copies and pass them out to landlords and tenants. And it's really helpful information about the rights and responsibilities of landlords and tenants from the beginning of the landlord-tenant relationship all the way to the end. All right, so we've gone 35 minutes over the actual scheduled time. I appreciate you all bearing with us. If there are any questions, we'll take them with the caveat that we cannot give you legal advice.
And
Will you be emailing a copy of the slide deck to us?
you read my mind. I will be sending everyone the recording of tonight's presentation, as well as the PDF of the slides. So any addresses, emails, etc. you didn't catch, you'll have them in your email inbox. If you didn't sign up and you walked in, make sure you leave me your email address.
Okay. Any questions? Any questions from the online attendees that you want to drop in the chat? Okay, I would be remiss if I did not mention that 2025 is a year of judicial elections. I'm not mentioning any particular candidates, but to the extent you are a registered voter and you care about who makes decisions in court cases for you or the people you love, I encourage you to pay attention to the judicial elections this year. There are a lot of open seats in important courts in this county and across the Commonwealth. And the way your voice is heard is by showing up and voting on primary day and general election day. And I know PMC has a couple of really cool workshops and seminars coming up, both about like the code of judicial conduct, which I have signed up to attend because I wish something like that had been available when I was running.
February 12th, pmconline.org.
And then I feel like I've seen one recently talking about how judges are elected. I'm not sure if that's a PMC one or not, but judges are important, and caring about who your judge is when you're walking into the courtroom is too late. When you care and when you have a say is on election day. So make sure you're registered to vote and show up and vote.
Absolutely. Stay tuned for more programming. Thank you so much for being here tonight.